I'm certainly happy to embrace the limited public forum analogy that I think has been the subject of some of these questions, because at the end of the day, I think it ends up in the same exact place as intermediate scrutiny, and if I could try to explain why. So two things are important about the limited public forum reasonableness test. The first is it's not rational basis. There's something more going on there. If you look at the opinions in Christian legal society on both sides, I don't think anyone on the court thought that they were engaging in rational basis review. So there's some assessment of whether the fit is appropriate, and some lower courts have likened that to intermediate scrutiny. I know your question earlier suggested that it's different, but I actually think that the reasonableness review and intermediate scrutiny are more alike than they're different, and neither one is rational basis. But the second point, and I think this is critically important in this context, is there's a nexus requirement that exists in the limited public forum set of cases. The question for the court isn't whether the restriction at issue is reasonable in light of any purpose, but in the light of the purpose of the forum. And even if you want to accept the idea that the forum here is not the government registrar, but the government registration system, I think the problem for the government is this clause really has nothing to do with that. And you know,
why are you saying that? Why are you saying that? I mean, Mr. Stewart just made a very robust argument about why this is advancing the purposes of the trademark regime.
Well, the purposes of the registration system, Justice Jackson, you can see this in McCarthy, Section 19.2. The goal of the registrar is to make registration and use as coincidental as possible. Basically,
no, but it's not just it's the trademark regime of which registration is a part. And trademark is not about expression. Trademark is not about the First Amendment and people's ability to speak. Trademark is about source identifying and preventing consumer confusion. And it seems to me that Mr. Stewart was making the point that by having a restriction on people trademarking living people's names, the government is actually furthering the interests of the trademark system because it prevents confusion regarding whether or not this is endorsed by the living person, this is the living person's thing. You can imagine a lot of circumstances in which having a trademarked name could cause confusion in the marketplace. So why is that not a rational basis for saying we won't allow people to trademark names?
So you're absolutely right, Justice Jackson, that the purpose of trademark law in general and the purpose of the registration system, as the opinion of the court in the Jack Daniels case from earlier this year makes clear, is to ensure that marks function as trademarks, that is, that they function as source identifiers, and they're not likely to confuse or mislead consumers as to the source. You're totally right about that. That's the purpose of trademark registration and the trademark system more broadly. But what's so unique about this clause is there are a whole lot there are other provisions of the Lanham Act in Section 2 that deal with the hypothetical that you just gave.
So you're just saying it's superfluous. That doesn't tell me it doesn't have a nexus to the purpose.
Well, I think in analyzing whether the provision that is before the court is constitutional, I think it's appropriate for the court to take account of the practical effect that clause has, because if it's invalidated, then the government is still going to have ample tools at its disposal to ensure that there's marks are not registered if they may falsely suggest a connection between a product and living persons, if they're deceptive, if they're likely to confuse or mislead as to source, if they don't function as trademarks.